The lawyer who sued himself into bankruptcy. If you think you know how this ends, you don't. Thomas Vale stood in front of a bankruptcy judge in 2019 holding a single piece of paper. Not a legal brief, not a motion, a receipt for $47,000 paid to himself. The judge asked Mr. Vale, "Did you really sue yourself?" Thomas looked up and said, "Your Honor, I had no choice." This is the story of the lawyer who turned the legal system into a weapon and aimed it at his own head. Thomas Vale wasn't supposed to be a lawyer. He grew up in a one-bedroom apartment in Queens, New York. His parents ran a dry cleaning shop. They worked 16-hour days and still couldn't afford health insurance. When Thomas was 12, a landlord tried to evict them over a $200 dispute. His mother begged. His father pleaded. The landlord laughed and said, "Get a lawyer." They couldn't. Thomas never forgot that feeling. Powerless, invisible, broke. So he became the thing they couldn't afford. By 32, Thomas was a senior associate at Dalton & Fry, a mid-sized firm in Manhattan. He wasn't flashy. He didn't drive a Porsche or wear Rolex watches, but he was obsessed. He'd work until 3 a.m., sleep in his office, then wake up and do it again. His specialty? Employment law, wrongful termination, workplace discrimination, wage theft. He represented the little guy, and he won. In 2016, Thomas took on a case that would change everything. A client named Sarah Vega had been fired from a tech startup after reporting sexual harassment. The company offered her $15,000 to go away quietly. Thomas said no. He took it to trial and won a $1.2 million settlement. Sarah hugged him in the courthouse and said, "You gave me my life back." Thomas felt something he hadn't felt in years: pride. But the firm saw something else: money. The managing partner, like Gregory Dalton, called Thomas into his office the next day. "You did good work, Val. Real good." Thomas waited. "But the fee structure on this case, it's a little unclear." Thomas's stomach dropped. "What do you mean?" Dalton leaned back in his chair. "You worked the case solo, no support staff, no co-counsel. So technically the contingency fee, that's $400,000, should be split with the firm, 60-40. Thomas stared at him. "I brought the case in. I worked it for 2 years. Alone." Dalton smiled. "And we gave you the platform to do it." Thomas left the office with $160,000 instead of $400,000. He didn't argue. Not yet. 3 months later, Thomas brought in another big case, a class action lawsuit against a restaurant chain for wage theft. He spent a year building it. Interviews, depositions, financial records. The case settled for $3.8 million. Thomas's cut, by contract, should have been $950,000. The firm gave him $340,000. When Thomas asked why, Dalton said overhead, resources, firm reputation. Thomas said, "I did the work." Dalton said, "And we made it possible." That night, Thomas sat in his apartment with a bottle of whiskey and a copy of his employment contract. He read it 7 times. Then he saw it. A clause, buried in Section 12, subsection C. Any dispute arising from compensation allocation shall be resolved through binding arbitration, unless the associate files a formal claim within 30 days of the disputed payment. Thomas checked the dates. He had 6 days left. But there was a problem. The only entity he could sue was the firm. And if he sued the firm, they'd fire him. And if they fired him, he'd lose access to all his active cases, including the ones that could make him millions. So Thomas did something no one expected. He created a loophole. He filed a lawsuit against himself. Here's how it worked. Thomas set up a shell LLC called Vale Legal Consulting. He transferred his contingency rights to the LLC. Then, as Thomas Vale, the individual, he sued Vale Legal Consulting for breach of fiduciary duty, claiming the LLC owed him unpaid fees. The lawsuit was real, filed in New York Civil Court, docketed, public record. And because he was both plaintiff and defendant, he controlled the entire case. He scheduled depositions, he filed motions, he even took himself to arbitration. It was legal theater. But it bought him time. The firm didn't notice at first. Thomas kept working, kept winning. In 2017, he closed 4 major cases, total settlements over $9 million. But every time, the firm shorted him, and every time Thomas added it to his self-lawsuit. He was building a paper trail, a record of every dollar they owed him. By 2018, Thomas's self-lawsuit had grown into a 300-page document. He had emails, recorded calls, spreadsheets. He had proof that the firm had systematically underpaid him and dozens of other associates for years, but he still couldn't go public. Not yet, because the moment he did, they'd destroy him. Then Thomas made a mistake. A paralegal at the firm, a woman named Joy Park, noticed something odd. Thomas had been requesting old case files from cases he hadn't worked on. She flagged it to Dalton. Dalton called Thomas in. "What are you doing, Vale?" Thomas kept his face blank. "Research." "For what?" "A case." "What case?" Thomas didn't answer. Dalton leaned forward. "Are you building something against us?" Thomas met his eyes. "I'm protecting my work." Dalton's face went cold. "You're done here." Thomas was fired the next day, escorted out by security, his cases reassigned. His office cleared. He walked out of that building with a cardboard box and a lawsuit no one knew existed. 2 weeks later, Thomas did the unthinkable. He amended his self-lawsuit. He added Dalton and Fry as a co-defendant. He claimed that the firm had colluded with Vale Legal Consulting, which, of course, didn't exist as a real entity, to defraud him. It was legal jujitsu. The self-lawsuit became a whistleblower case. The firm's lawyers laughed at first. They filed a motion to dismiss. "Your Honor, Mr. Vale is suing a company he created. This is frivolous." But Thomas had anticipated that. He argued that the LLC, while technically his, had acted as an agent of the firm because the firm had directed how his fees were allocated. The judge paused. "Counselor, this is unusual." Thomas nodded. "Yes, Your Honor, but not illegal." The motion to dismiss was denied. The case went to discovery, and that's when everything unraveled, because Thomas wasn't just fighting for himself anymore. He subpoenaed the firm's payroll records. He found 12 other associates who'd been underpaid. He found emails from Dalton instructing HR to reallocate fees without telling the attorneys. He found a secret account where the firm had stashed over $4 million in unclaimed contingency fees. The firm panicked. They offered Thomas $500,000 to go away. He said no. They offered $1.2 million. He said no. They threatened to countersue. Thomas smiled and said, "Good. I'll depose Dalton under oath." In 2019, the case went to trial. But not the trial Thomas wanted, because the firm had done something brutal. They'd filed for bankruptcy, Chapter 11 reorganization, and under bankruptcy law, all pending lawsuits are stayed. Thomas's case was frozen. He sat in that courtroom watching the firm's lawyers argue that Dalton and Fry was insolvent. The judge asked, "Mr. Vale, do you have any objection?" Thomas stood. "Your Honor, I'd like to submit evidence that the firm transferred $8 million to offshore accounts 3 days before filing bankruptcy." The courtroom went silent. The judge looked at the firm's lawyers. "Is this true?" They didn't answer. The bankruptcy was thrown out. The case resumed. And in November 2019, a jury awarded Thomas $4.7 million in damages. The firm was ordered to pay an additional $2.3 million to the other associates. Dalton and Fry dissolved 6 months later. But here's the twist you didn't see coming. Thomas never collected a dime. Because the firm had hidden the money so well, even forensic accountants couldn't find it. The $4.7 million judgment was worthless, and Thomas had spent over $300,000 of his own money funding the lawsuit. He was broke. The bankruptcy judge asked him, "Mr. Vale, was it worth it?" Thomas looked at the empty defense table, at the firm that no longer existed, at the partners who'd fled to other jobs, and he said, "Yes." Because 3 months later, Thomas received a call from a lawyer in California. "Mr. Vale, I read about your case. I have 40 clients who were underpaid by their firms. Will you represent them?" Thomas said yes. And then another call came, and another. By 2021, Thomas had built a new practice, not as an associate, as the guy who sues law firms. He's won over $30 million in settlements. He's never taken a case for less than 40% contingency, and he's never worked for anyone but himself. He still has the receipt, the $47,000 he paid to file the lawsuit against himself. He keeps it framed in his office. Underneath a note, "The best investment I ever made." Thomas Vale didn't sue himself into bankruptcy. He sued himself into freedom. And sometimes, the only way to win the game is to rewrite the rules. If you made it this far, hit subscribe.